Jeremy, as you can see, I'm sure you're noticing a trend or a theme, which is like equity, right? We try to really make these equitable.
Right.
And that kind of leads me to another provision that I always make sure to look out for, and that's the importance of reviewing any non-solicit or non-compete language. You know, there are two issues that I personally constantly see when I'm reviewing these agreements when it comes to non-solicit, non-compete. First is that a lot of the times the agreement language is actually not, you know, the way they draft their non-competes are not even legal in the state that agreement is being governed under. So California, for example, has very strict laws when it comes
there
to...
is no non-compete.
There is no non-compete except a very minor...
Just so anybody who works in California, just so you know, not only is there a prohibition on non-competes include non-solicits.
Yep.
Welcome to the Payments Experts Podcast, a podcast of Global Legal Law Firm. We hope you enjoy this episode.
If you were a worker, and there's a question whether it extends to independent contractors, but if you're in California, there is no such thing as an independent contractor, really. If you, for whatever reason, have a non-solicit thrown at you, even that can probably be invalidated, and most people don't know it. Like, it's just one of those things where, like, there's no issue. Now, you go to another state, like Texas is a good one.
Texas, Florida.
Yeah, they actually have really precise non-compete statutes where it has to be limited in its temporal scope, can't be for too long, can't be for too big of an area.
It has to be reasonable.
Yeah, it has to be reasonable. Yeah. Like, so, you know, if you're an ISO and you only do business in 4 states and you say that they can't compete with you for a year nationwide, that's not reasonable, right? Yeah. Like, so, you know, you have to pay attention to what's coming at you, and you have to look at how broad the language is. Like on the non-solicits, like I always find that they're just way too broad.
That was the second issue I was going to bring up, was that. So the first issue is that oftentimes they're just drafted in a way that's not actually enforceable under a certain state's law. California just being a great example of that. It's funny, Chris mentions, you know, some of the examples of non-reasonable are, you know, they try to prohibit any solicitation across the country. I've seen some where it's across the entire world.
Yeah.
They're just prohibiting you from doing business anywhere on earth, I guess.
But that's because they're just grabbing contracts and they're like cobbling them together, or they're using AI.
Yeah.
And they don't know how to use AI.
Know how to use it, yeah.
And what they're pulling down from AI are a bunch of clauses that might not actually assimilate with one another.
Yeah. And then so the second issue that I was going to say that I always see is non-solicits that are too broad, where they will just lay out such a long paragraph of all these different entities and parties that the agent cannot solicit. And again, not only does this violate a lot of states' laws because it's just far too broad and unenforceable, but my bigger issue is just these entities, these parties, they're not even under the scope of what we're doing here. Under this relationship, it's the referred merchant that the agent should not be allowed to solicit away from the ISO.
That's like saying I go out and I resell for somebody who resells AT&T, and I can't do any business with AT&T ever on my own, right? I mean, there's just nonsensical terms in these agreements. Yeah. The one that I always see is, so, like, look, we live in a capitalist society. Competition, like anti-competition statutes matter, and competition's promoted. When you basically tell me that I'm going to be in violation of a contractual provision for things that I don't even know.
Right, when they list like any of my vendors.
Yeah, like
I don't know your vendors.
Yeah, I don't know your vendors. Like, I don't know your other merchants. Like, I only know the people that I dealt with you, right? Like, so what is, I guess it's probably better to say what is off limits.
Right.
What's off limits is when you refer a merchant to your upstream vendor for a particular service. You can't undo that. Like, you've done it, you've created a contract, you have to abide by the contract so long as they continue to pay you. Now, if they materially breach the contract and they stop paying you for some BS reason, then at that point in time, there's a question of whether or not you can go and recapture that person. Another place that I see this is it's not just non-solicits, it's also in confidential information, right? Everybody wants to say, that's my trade secret, that's my confidential information. Really? Your relationship with your acquiring bank, which is required to be disclosed at every potential offer to a merchant and on your website, That's your confidential information, really? Like, it's the like ludicrousness of how people want to read these contracts to say that they're enforceable. All right, let's talk to the judge, because I'm not really interested in trying to convince you how what you're saying is just horseshit right now. You know?
And I really want to hone in on one of the things Chris said is, you see it all the time with these non-solicits where they do list out so many different entities. Like, the agent cannot solicit any of the vendors, affiliates, and affiliates isn't defined. So does that mean any parties you're affiliated with, or does it mean a party that you own, right? They just list it they make it so broad where just by the agent entering into the agreement and executing the agreement, you might already start violating it from day one, because maybe you're already doing business with those parties.
Well, there's another spot. I'll finish on this one, but think about it from this perspective. Say I run a call center, and that's how I do my marketing, and I'm just buying legitimately lists of bona fide businesses to call on. Right? I call, I give my pitch. Maybe I have multiple calls, and finally the merchant on the other end says, "You know what? I'll send you my current merchant statements." It happens to be for somebody that you used to partner with, right? At that point in time, am I really, after I've spent money on good faith marketing, and I learn right before I'm going to sign these people that they happen to be contracted at some point with these people over here, am I really now, after I've done all this stuff, supposed to not go forward? That's a restraint on trade. I'm in free trade. I am doing things that I'm legitimately allowed to do. I'm not using anything that you gave me. I have no idea that you have any relationship with this merchant. I mean, because here's the thing. I'm non-exclusive. I'm a non-exclusive agent. I'm allowed to work with multiple people. Mm-hmm. What happens that I've signed these competing agreements that I run up against somebody? And now I'm in constant fear because, I'm going to have my residuals shut off because I went and took a merchant and I was able to give them a better deal over here. Like, I think at a certain point, you've got to kind of find an agreement with the other side about that particular instance. I see the same thing with employees, right? Legitimately, you can't work with somebody and then go and poach that person. Like, that's not something that you're supposed to do. It's just like you're not supposed to poach your merchant absent a material breach. I've even seen language in a contract that says not only can you not solicit, not only can you not interfere with an existing relationship, you cannot hire.
Yeah.
So we have worker mobility rights in this country. That's a restraint on free trade. You're basically robbing a worker of their ability to go and apply for a job that's publicly listed. Really? You're telling me I can't hire that person? So like Leo, that's where Leo's really good, is he rolls into these restrictive covenants and just carves them up.
Yeah, and on that point, in the more extreme examples, not only do they have language where you can't hire anyone from the ISO, but again, they do that whole same thing, a laundry list of you can't hire from the ISO's employees, the ISO subsidiaries employees, the ISO's affiliates, vendors. Again, like, we don't know who your vendors are. We don't know who these affiliates are. And you're just restricting freedom of employment across so many different avenues. And this, Jeremy, is why I think this podcast is so important, because really you got to review your agreements. You got to anticipate problems so that you can alleviate issues down the road.
Thank you for listening to this episode of the Payments Experts Podcast, a podcast of Global Legal Law Firm. Visit us online today at globallegallawfirm.com.